there! My name is Tasnim. Let's talk about what is the doctrine of precedent. The doctrine of precedent is a fundamental principle of English law. It's a form of reasoning and decision-making formed by case law. What is precedent? So, a reasoning behind a court decision that establishes a principle or rule of law that must be followed by other courts in the same court's hierarchy when deciding future cases that are similar facts. Next, judges look at past decisions to guide them in deciding later cases. So, next is judges look at the reasons behind the decisions, which is called ratio decidendi in past cases, for guidance when deciding new cases. And next, the general idea behind the doctrine of precedent is that judges, when they are deciding cases, must pay proper respect to past judicial decisions. This can be seen in that impacts of precedent later, which is going to be covered by the child. The importance of precedents. In a common law system, judges are obliged to make their rulings as consistent as reasonably possible with previous judicial decisions on the same subject matters.
Now there are three types of precedents, starting with the original precedent. This is essentially what is referred to as the initial new precedent that is to be set, as no previous decision that can be referred back to or followed by the judge can be found. There will be new sets of ratio decidendi to follow in similar future cases. Typically, judges would give reasons by analogy as there were no records of earlier decisions that can be followed. Cases with a few menial similarities, however, may be referred back and consulted upon. One famous case example of the original precedent would be the case of Donahue and Stevenson in the year 1932. It is a case that brought upon huge developments in negligence law. Although there was a concept of duty of care within particular circumstances, this case has widened its application and created a point of law known as the neighbor principle. Now the binding precedent, that is where present cases are to follow previous decisions when a sufficient similarity of the facts in the later case and the previous decision was made from a higher precision court or courts in the same level of hierarchy. What this essentially means is that inferior courts are bound to follow decisions of the superior courts when dealing with similar cases in the future. Now persuasive precedents. They tend to be more flexible on their sources. Despite not being bound by the court hierarchy, judges are still able to use this type of precedent if or when it deems to be necessary for the case or sufficient reasoning. Not only is it open to use for obiter dicta, it is also open to the precedents made by the lower courts. One case example of this would be that of R and God in the year 1992, where the Court of Appeal followed the obiter dicta of R and Howe that took place in the year 1987. Using this case as a persuasive precedent on deciding the non-availability of duress as to a charge of attempted murder. In addition, a dissenting judgment of disapproval of the majority and decisions made in other countries can also be used as a persuasive precedent. This can be found in the case of McLovin and O'Brien, which was about nervous shock due to negligence. Persuasive precedents can be from treaties, decisions from the Privy Council, and even law review articles within the right extent of reputation of the author and the relevance to the case.
After learning about binding precedents, one will need to know the process of how judges apply binding precedents to similar cases. This process is known as judicial precedent. Now imagine that you are a judge. A case comes before you in court. You will now need to ask yourself these questions. These are 5 crucial questions, and these questions will help determine the decision that you will make. Firstly, you have to look at the facts of the case, which is the first thing that you do. I'm going to use the Court of Appeal case of Jones and Padavatten to illustrate. Mrs. Jones, which is the mother of Mrs. Padavatten, wanted her daughter to give up her job as a secretary in the US and head to England to study for a bar. The mother said that she will cover her expenses, her daughter's expenses, while living in the UK. And a while later, Mrs. Jones bought a house in the UK and said that her daughter could live there. A quarrel arose and Mrs. Jones wanted possession of her house back. However, Mrs. Tadabata said that she could stay because there was a binding contract by the virtue of consideration. That was the facts of the case. Through that, you will then ask yourself, what was the issue? And in this case, the issue was whether or not there was a binding contract. Now comes the time to give your verdict on the case, which is the third. In this case, it was held that there was no binding contract. Once you have reached the verdict, you will then need to give reasons behind that verdict, which is the fourth thing that we're going to look at. And in this case, the reason is because there wasn't enough evidence to rebut that domestic relationships like this should have no intention to create legal relations. Lastly, you might also want to include your thoughts on the case. What do you think? Although it would be regarded as an objective dictum, which won't have any legally binding effect, it is healthy and at times a useful exercise of one's prerogative.
I'd like to talk about advantages and disadvantages of doctrine of precedent. Now, let's start with advantages. Firstly, consistency and predictability, which means everyone can rely on when there is an issue they face personally or professionally in court. Other cases will be treated and decided in a manner that is similar to past decisions. Also, lawyers are able to advise their clients with some certainty as to the position that they should take in their situation, and whether it's beneficial to take such a problem to the court system. Secondly, flexibility. Although judicial precedent may create a standard that applies to similar cases and situations, it's not a binding result. Higher courts do mandate that lower courts follow rules to the letter, but they can reserve the right to change their mind when an appeal court or issue in society change. Thirdly, time saving. Because the legal system already provides an answer for similar situations, judges can spend less time in deliberation, which results in fast and fair outcome for all the parties involved. Finally, fairness. Judges follow the judicial precedent in order to provide protection for the future victims when the law is consistent. Now, let's move to the disadvantages. Firstly, complexity. There is too much case law and it's too complex and difficulties in deciding what the racial disadvantage is, particularly if there are a number of reasons. Secondly, rigidity. The rules which are created from judicial precedent can remain in place for a long time. It's usual for these writing or errors to apply even when they are outdated. Many judges will not make any changes to the perspective of law until a case comes through which requires such an action. Some changes require a case to come to a higher appeals court before new rules can come. This system leads to many outdated and meaningless laws that are enforceable today. Thirdly, it forces the justice system to look backwards instead of the future. A judicial precedent must always be looking backwards for it to create a standard in the first place. If someone finds themselves violating a rule based on what a judge has ordered in the past, that creates an unfair system of justice because the offense comes through the judgment instead of legislation. Finally, slowness of growth. That there may be a consideration wait for a case to come to court for a point to be decided. Only 50% of court of appeal cases go to the Supreme Court. Some areas of law are unclear and indeed follow reform. However, the court cannot make a decision unless there is a case before the court to decide. So that's all the advantages and disadvantages for our precedent.
How is the law to develop and change to cater for the changed circumstances and changing social needs if cases are always to be decided according to ageless precedent? There are certain judicial tools available to ensure that the law continues to develop. Since ratios are determined retrospectively, judges do have the flexibility in applying the precedent system. It is open to later judges to avoid precedent by declaring them to be no more than official statement. The first way is distinguishing, where the facts of the case before the judge are significantly different from those of the earlier one. Then the judge distinguished the two cases and did not follow the earlier one. Two cases demonstrating the distinguishing process are Balfour and Married. Both cases involve a wife and a husband for breach of contract. in Balfour, it was decided that the claim could not succeed because there was no intention to create legal relation. The second case was successful because the court held that the facts of the two cases are sufficiently different in that, although the parties were husband and wife, the agreement was made after they had separated. Furthermore, the agreement was made in writing. This distinguished the case from Balfour. The agreement in marriage was not just a domestic agreement, but meant as a legally enforceable contract. The second way is overruling. Where the earlier decision was made in the lower court, the judges can overrule that earlier decision if they disagree with the lower court statement of law. The outcome of the earlier decision will remain the same but will not be followed. For example, the Supreme Court overruling a decision of the Court of Appeal. An example of this was seen in Paper and Hart when the House of Lords ruled that Hansard could be consulted when trying to decide what certain words in an Act of Parliament meant. This decision overruled the earlier decision in Davis and Johnson when the House of Lords held that it could not consult Hansard. The third way is reversing. This is where a court higher up in the hierarchy overturns the decision of a lower court on appeal in the same case. For example, the Court of Appeal may disagree with the legal ruling of the High Court and come to a different view of the law. In this situation, it reverses the decision made by the High Court. There's another way to avoid precedent, which are by using practice statement. The House of Lords was traditionally bound by its own decision, but in 1966, the Lord Chancellor issued a practice statement saying that the House of Lords was no longer bound by its previous decision. The practice statement allowed the House of Lords to change the law when it believed that an earlier case was wrongly decided. It had the flexibility to refuse to follow an earlier case when it appeared right to do so.
The first major use was inherited and British Railways Board, which involved the law on the duty of care owed to the child trespasser. The earlier case of Annie and Dombrag had decided that an occupier of land would only owe a duty of care for injuries to a child trespasser if those injuries had been caused deliberately or recklessly. In Harrington, the Lords held that the social and physical conditions had changed since 1929, and the law should also amended as it was no longer acceptable that a property owner should have limited responsibilities to the trespassers. Next, the practice statement stressed that criminal law needs to be certain, so the House of Lords did not rush to overrule any judgments in criminal cases. Next, the first use in the criminal case was in R.S. Shapiro, which overruled the decision in Anderton and Ryan on attempts to the impossible. The interesting point was that the decision in Anderton had been made less than a year before, but it had been severely criticized by academic lawyers. The House of Lords recognized that they might sometimes make errors, and the most important thing then was to put the law right, where the practice statement is used to overrule a previous decision. That past case is then effectively ignored. The law is not that which is set out in the new case.
Common law reasoning. Law is expressed in a language that requires interpretations. Once interpreted, the law then has to be applied to the facts of a particular case. In the English common law, this process is known as legal reasoning. So what is legal reasoning? Let me tell you. Legal reasoning requires an understanding of the doctrine of binding precedent, including the concepts of ratio decidendi and obiter dicta, and the way in which the courts approach the task in legislative interpretation. Legal reasoning requires the understanding in doctrine of binding precedent, approaches in legislative interpretation, concepts of ratio decidendi and obiter dicta. Next, in common law reasoning, the judges make law? I don't know, wait. Okay, here's the thing. The declaratory theory by Williams Blackstone. Judges do not make law. It is the function of the legislature to make law and then the function of the court that should apply the law. By virtue of the doctrine of precedent, judges discover and declare the law that has always been. Hence, parliamentary sovereignty is preserved. However, let's take a look at in Claiborne Madison Lincoln City Council. Lord Brown, Wilkinson said, the theoretical position has been
been that judges do not make or change the law. They discover and declare the law which is an earlier decision is overruled. Okay, stop. Below ground, the theoretical position has been that judges do not make or change the law. They discover and declare the law which is not the same when an earlier decision is overruled. The law is not changed. Its true nature is disclosed having existed in that form all along. In truth, judges make and change the law. The whole of the common law is judge-made, and only by judicial changes in the law is the common law kept relevant in the changing world. So, judges' ability to make law, is that right? Let's see. Judges can only make law when they are deciding on a new issue, novel case, brought before them, or when a previous principle of law requires expansions to apply to a new situation. Example is the Donohue Stevenson in 1932. The first time a case of the damages was brought to court, it was a novel case that it created the common law of damages. Further cases over time have developed the common law. Example, different duty situations, economic laws, psychiatric injury, and others.
The principle of stare decisis has been an integral part within English judicial systems and has much played a part in its development. The idea that courts are to follow past decisions has no doubt helped in the development in all aspects of the law. The doctrine of precedent can also be seen to go hand in hand with Dicey's principles in regards to the rule of law. For example, the second principle states that there is to be equality among all citizens, and that the law is made to maintain order within society and provide a harmonious environment for the sake of social progression. The doctrine of precedent can be seen to further strengthen and enforce this principle as its way of having judges use past decisions as their guide. With this, judges are able to further predict the conclusions of a case while at the same time still ensure the fairness of all trials. Because surely, if everyone gets the same kind of result, it would mean that there is equality within the law, wouldn't it? However, this notion of looking back into the past has also raised some concerns. The chances of having a case be repealed after a conclusion was drawn may be very slim if the chances of having the decision reversed itself seems to be slim. Courts may use past cases to draw a conclusion in a more effective manner even if the decision may be unjust at times, and this is where the principle of stare decisis may be slowing down the development of the law. Is it truly a good option to have an ever fast evolving society be bound by cases that were set in the past? Not only that, inferior courts are said to be bound by decisions made within the superior courts and are set to follow them, even if the decision that was made seems to be unconstitutional or unjust. Is it truly fair for our judicial system to follow a precedent that is seemingly stuck in the past?
As a conclusion, the doctrine of judicial precedent stems from the principle of stare decisis, which means that previous decisions of the court should be stood and followed by in later cases. This doctrine helps to ensure there is consistency and fairness in the deciding of a case, as a judge does not have to start from scratch, but can refer back to past cases for assistance. Precedent can neither be binding or persuasive, depending on which court decided case.
The general rules of precedent are that the higher courts bind the lower courts. A court on the same level of the hierarchy like Court of Appeal will be self-binding, and the lower court do not bind other court. The European Court of Justice is binding upon all lower courts, even the House of Lords, on matters of interpretation of European Union law. The Human Rights Act 1998 must be taken into account when considering precedent of cases, as the court under Section 2 is required to ensure that the ECHR decision and principle are taken into account when considering domestic law.